Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to talk about important weekly legal news from 18th April to 23rd April 2022. In first important news, the Supreme Court has held that gift of ancestral property of a Hindu undivided family can be for pious purposes only. In the case of K.C. Lakshmana versus K.C. Chandrappa Gowda, the Supreme Court has held that a gift of ancestral property of HUF can only be for a pious purpose. It cannot be out of love and affection. The court has held that it is well settled that a Hindu father or any other managing member of a HUF has power to make a gift of ancestral property only for a pious purpose, and what is understood by the term pious purpose is a gift for charitable and or a religious purpose. Therefore, a deed of gift in regard to the ancestral property executed out of love and affection does not come within the scope of the term pious purpose. In second important news, the Supreme Court has held that an ad hoc employee can only be replaced by a regularly appointed candidate. In the case of Manish Gupta versus Jan Bhagidari Samiti, the Supreme Court has held that an ad hoc employee cannot be replaced by another ad hoc employee. He can only be replaced by a regularly appointed candidate. The court has said that it is a settled principle of law that an ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following a regular procedure prescribed. In third important news, the Supreme Court has upheld the constitutional validity of Maharashtra Protection of Interest of Depositors in Financial Establishments Act. In the case of State of Maharashtra versus 63 Moons Technologies Limited, the Supreme Court has rejected the challenge against the constitutional validity of the state law, that is Maharashtra Protection of Interest of Depositors in Financial Establishments Act, on the ground of overbreadth of certain provisions relating to attachment of property. Lastly, the Supreme Court has held that insider trading cannot be presumed merely because the parties are in close relationship to each other. In the case of Balram Garg versus Securities and Exchange Board of India, the Supreme Court has held that insider trading cannot be presumed merely on the basis of proximity between the parties. The onus is on SEBI to establish the same. The Supreme Court has clarified that under Regulation 2 Clause 1 of SEBI Prohibition of Insider Trading 2015 regulations, the onus is on SEBI to prove communication of the unpublished price-sensitive information. This brings us to the end of our weekly legal update. If you like this content, please like it, share, and subscribe to our YouTube channel.